everyone. Welcome back. Please take your seats. Hi, welcome again, and we shall resume our session. So before we start our first panel, I observed that from our previous open discussion session, it seems that our audience today are very engaging and very responsive to our topics. So in our earlier session, we've mentioned that today's conference is a rather multidisciplinary one, with people from different sectors joining in. So I would like to take this chance to to show everyone how many sectors and how many different types of audience we have today. So actually today we have representatives from Children Commission, the newly established body. Can people from this body just wave your hand so that we can see your support? Thank you. Thank you for coming. Yes, and we also have some NGO members joining. Where are you? NGO, yes. Thank you. Thank you for coming. And also the legal sector as well. Lawyers. I can raise hand on this as well. And also medical sector. Yes, thank you very much. And I hope that the upcoming discussion would be as diverse as our audience base is. So now we'll have our first panel session, Making Children Visible in Policy Development, Ensuring Children's Effective Protection Against All Forms of Violence. May we now invite our panelists to come on stage. They are the Honorary Dr. Fernando Cheung Chiu Hong, Member of Legislative Council. Dr. Chow Chun Bong, BBS JP, Honorary Clinical Professor, Department of Pediatrics and Adolescent Medicine, the University of Hong Kong. Mr. Dennis Ho Chi Kyun, Chairman, the Family Law Committee of the Law Society of Hong Kong. Mr. Anthony Wong Kin Wai, Business Director, Policy Research and Advocacy, the Hong Kong Council of Social Service. And our moderators, Professor Kapai and Ms. Block. Thank you.
Okay, everyone, thank you so much. Hope you had a short but sweet break. I just want to take a minute or two to do what I didn't get to do earlier because the slide was not loaded. All the panelists have received this framework and they have had a chance perhaps at least to read it. But I wanted to share with you how sort of some of these questions are meant to work. So you can see that in the center circle for the micro level child rights impact assessment, the question beginning with the sort of left mustard color sort of quarter is the child presenting with signs which warrant a follow-up? These may be physical, mental, emotional, or other signs of abuse, distress, disengagement, lethargy, neglect towards basic needs. And then what is in the best interest of the child under such circumstances? But what are the specific criteria or considerations I need to consider, whether clinically or in other sort of frames of reference, to determine and calibrate the best interests of the children affected. And it says children because even though you might be dealing with a child, there may be other children who might be affected by a similar situation. And then are there other family members? So moving to the third quarter, the green one, are there other family members, especially children, to be concerned about? What are the steps to take to safeguard their best interests? And then the last quarter, the blue one, has the child expressed his or her own view of the circumstances or incidents? And what would we need to do to make sure they feel safe? And if they haven't, what are the avenues to build trust or to have the child speak to someone they do trust? And does the child have requisite information about what their needs, what their rights are, or how their needs in the immediate sense can be met, and to form an informed view if they are at an appropriate age or maturity level to be able to do so, and to consult with a professional if they wish. And then to guide these considerations are the outer layer questions. And again, you start from the top, looking at family dynamics, right? Are there any aspects of the family dynamics or situation which you think might be a feature of risk-inducing circumstances? And is the child's health or well-being at risk now or in the future? What is the level of risk that you can identify? Is there a history of such kinds of a risk or situation in this family concerning this child or any other siblings or any other members of the family? So that's where the situation of domestic abuse Gladys highlighted earlier becomes pertinent, because you need to know that in order to determine the safety of the context in which the child is placed. And would inaction potentially lead to an escalation of the situation which impacts the health, safety, and well-being and developmental or survival rights of the child in the immediate or longer-term future, right? And then right down at the bottom, does the child require any attention from other experts or professionals, right? And then are their rights adequately protected through the professional assessment frameworks? And are they developmentally appropriate for the child concerned? Are there any other sources of information? If you don't have any, where can you turn to in terms of people who might have seen the child recently to gather or buttress the quality of factual information that you have at hand to better inform all of these assessments that you're making? And what is the appropriate time frame within which this situation needs to be managed? Is it one that calls for early or urgent intervention, or intervention after fact gathering, or once you hit a particular risk level? So as I said earlier, this is a process of triaging the incident and then determining where you sit and then documenting that decision and then pulling it up again when you're next reviewing the situation. And finally, two things. First, are there cultural, religious, or other factors which complicate the situation, which require a different set of analysis to be applied or assessment to be made entirely? Perhaps there could be stigma or unwarranted attention of outsiders, which could further put the child at risk. And is it my professional duty to act in light of the indicators that I have now compiled? What are these indicators? Are there issues pertaining to confidentiality that I need to be concerned about? Or is there a sufficiency of risk level that I can move outside the confidentiality framework? And how do these considerations weigh up to balance the child's best interests and make sure that it is at the center of my next action? So this is what I'm calling the intervention or the decision not to intervene. So I hope that that is a bit more useful and more concrete to give you a sense of the kinds of questions that we're trying to apply in the course of what is called the CRIA. And just again to say, this is at the micro level from individual sort of practitioners on the front line. There is a subsequent sort of meso level, which is the organizational or institutional level. And then, of course, you've heard about the macro level, which is more oriented towards government and other policymaking bureaus. Okay, so I'll leave that up in case that's helpful. And I'm going to hop over here.
Thank you so much, Professor Kapai, for delving a little bit deeper into this child rights impact assessment tool. As this panel will explore a bit further together, I just wanted to start with a question to Dr. Chung.
Yes.
As a member of the Legislative Council, I was just wondering, to what extent does the current policy framework really allow for consideration of CRC, but also of how policy impacts children, and how the decision-making process takes that into consideration?
I think the main problem with the current framework, if you will, is that we have concerns or paramount concern for parental rights. And when parental rights conflicts with best interest of the child, parental rights usually I should say always, prevails. And we don't have a legal framework, a local law, to require that the best interest of the child be considered or in any way implemented. So what we're looking at is, for one, the system has to protect the parental rights, and oftentimes disregarding the best interest of the child. And number two, because of the lack of services, lack of resources, lack of support, the best interest of the child is usually compromised. And we're looking at any time any point in time that there could be 30-some to 60-some children, for example, stuck in the hospitals without medical needs, not because they have any need for medical care, but because there's shortage of services. And in considering whether we would trigger the care or protection order, our professionals many times would avoid it at all costs because it would require a lot of responsibilities and works. And because of lack of manpower, that isn't triggered. And even if that is applied, the court does not have any oversight of care plans or permanency plan involved. Oftentimes, when we look at abused situations, the siblings could be placed in different institutions. There isn't any consideration for the siblings to be put together. These are, things that are happening on a daily basis, and yet we're talking about the best interest of the child. I don't see how the best interest of the child can be guaranteed or assured unless there are local laws enacted that says specifically that the best interest of the child has to be considered in any of these proceedings or applications for any protection orders. Otherwise, it will continue to be an academic concept, something that we sign on to, but in reality, it is a diversion or shirking of responsibility. It is a paramount parental rights dominating the rest of our practice.
Can I just interject there, Fernando? I mean, so in the morning I was describing how there are countries who have these principles in their laws and even in the constitution. So Norway has the best interest principle enshrined in the constitution. But even then, the CRC committee has asked that it provide specific criteria of what are the considerations that amount to sort of the best interest principle. And I think that that necessarily has to be tailored to each jurisdiction given its context. And so we're not even at the first stage. But if we were to sort of come up with a set of criteria, what could those be? How can we make children's interests more visible in these processes that you're talking about?
Well, actually, I'm writing a private member's bill on child protection, and Azan Mawa is the responsible person in drafting it for me. There is a checklist that we adopted from what has been considered in the children's bill that was supposedly about to be proposed. But I think the government has dropped it. If you would allow, I can read out some of these
Yes,
points.
Sure.
I would require the Director of Social Welfare to consider all these as a checklist when it comes to any application of any power under this ordinance. And I would also require the court to bear this in mind. And these would include the ascertainable views of the child concerned, the child's physical, emotional, and educational needs, the nature of relationship of the child with each of the child's parents, siblings, and with other persons, the likely effect on the child, any change in the child's circumstances, the child's age, maturity, sex, religious faith, social and cultural background, and other characteristics of the child that the court considers relevant. Any harm that the child has suffered or is at risk of suffering, the child's relationship with and emotional ties to a parent, sibling, relative, or other members of the child's extended family or member of the child's community. The importance of the child's development of a relationship with a parent. The importance of continuity in the child's care and the effects, if any, on the child's disruption of that continuity. Any family violence involving the child or a member of the child's family. How capable each of the child's parent or any other person in relation to whom the court considers the question to be relevant is of meeting the child's needs and the risk, if any, that the child may suffer through being removed, kept away from, returned to, or allowed to remain in care of such persons. The practical difficulty and expenses of child having contact with the parent, and whether that difficulty or expense will substantially affect the child's right to maintain personal relationship and direct contact with his or her parents on a regular basis. The range of power available to the court and any other circumstances the court considered relevant.
So the question then becomes, if this is sort of the blueprint, how can this then also be shared with by other professionals who have access to children? Or do we always require the court's intervention before this composite set of factors can be considered?
I think the court's intervention should be the last resort. I think oftentimes we do not want to go through legal proceedings to resolve family problems, right? We want to resolve it at the very beginning. So I wouldn't think that this checklist would necessarily be applicable to all situations, certainly not in many of the counseling or decisions at a more micro level. But with this in place, we do have a sort of a safety net that if all fail, everything else fail, then we can come to this and at least we have a yardstick to go by. And that when it really comes to invoking legal protection for the child, these considerations are in place.
If you touch upon certain situations already, just to come back to return to that, but what particular challenge then exists to make children more visible in those policies? I mean, you highlighted some of the, some challenge regarding, because I'm aiming at what groups of marginalized children are particularly vulnerable, and to make sure that they are particularly included. You mentioned some of the hospital situation, for instance, but are there additional concerns to make sure that they are reflected?
Well, there are many marginal groups that we can name. One is that children that are in families with substance abuse. We're looking at an increasing number of substance abuse families. I was just speaking to Susan Choi, who is the head of an NGO. She said 80% of her referrals, she's running these homes for children who are at risk. 80% of them come from families who are in substance abuse. It's an alarming figure. It's something we need to consider. And of course, we should look at children from poor families, single parent families, children of ethnic minority background, especially those who do not even have a legal status in Hong Kong, asylum seekers. These are children who are at a higher risk than our general population.
So building on that, if I can, so Fernando, you've highlighted sort of how the the incorporation of these items into law to secure the best interest principle would be a very fundamental basis to inform then the rest of policy and decision making and practice, and hopefully the courts can then step in when called on to ensure that right is done by those groups of children. But as you said, we can't leverage that at every occasion. There have to be other processes in place to buttress sort of the lead up to that sort of level of escalation. So I'd like to ask our other panelists then, Dr. Chow and Mr. Wong and Dennis as well, from your respective disciplinary frameworks, what's the value of the Child Rights Impact Assessment framework that I've shared with you? Does it help to try to bring some of those principles that Fernando's outlined to make them more relevant to your day-to-day sort of practice or management, whether it's sort of at the institutional level or individual level of practice? So we've got the representation from obviously medicine and then law and social work. So perhaps we'll start with you, Mr. Wong. Yes, sure.
Yeah. I think the framework itself is very good to capture, at least to give the practitioner some questions to ask themselves. But as you mentioned about this meso level, talking about organization and institutional level, I would like to add that even if we have a very sophisticated legal framework with all this framework of assessment, but I think we have to make it like a campaign. It's like as Fernando has said, some of the practitioners at the organizational level or at the department, they would rather not to take that responsibility. They would rather use it very proactively. So you have to make an effort to try to engage them, get them convinced that this framework is useful. You have to create a sort of a momentum so that all the people would endorse this framework. And also you have to establish some kind of organization practice code or among networking the organization so that this can create some kind of cultural or social forces so that these people would be constantly being reminded that this framework is actually behind our work. So I think, because our council is actually a network organization, of course, so usually we would, many people will have a lot of therapy or framework or model to promote. But the most important thing is that how you engage all this organization and all the sectors to get this framework or model endorsed and then actually use it in the practices. I think this is a very important process, and I think this is really go beyond having a framework or whether it's a legal framework or a conceptual framework. The other thing that I would like to add to is that because just now we've mentioned what are the disadvantaged group of children that we are most concerned with. I think one of the questions that I've been aware of for quite many years is that in Hong Kong we actually do not have much data and also we don't have a very organized group of people who could advocate based on evidence. Advocate for these different groups of people. So actually, we actually do not are not able to enumerate how many people are actually in disadvantage. So I think many years ago, I had an idea of creating a sort of a consortium, bringing together different people from different sectors to actually look into the problem of children of every different groups and then speak for them publicly. Advocate for their interests. I think this, I would still hope that this could be realized sometime. And also in terms of, because our council has been concerned with service and policy advocacy, sometimes when we come across some new proposal, for example, you may have heard that the government has just announced to give resources to primary school to get to hire a school social worker and help the people who are really in need in the school context. But in designing this service, well, of course, the sector actually welcomes this practice, this policy. But in designing this, whether we have actually considered the design of the service is actually for the interests of the children is actually quite questionable because, I mean, the responsible bureau would consider interest, I mean the existing interest of the school, rather than the children's interest. We've been talking about, like, for example, if you ask the school to hire a social worker, so the social worker become an employee of a school, then it would jeopardize the professional independence of a social worker who could make independent judgment of what is the best interest of the children, right? So I think the design of the services or policies usually sometimes we actually ignore the best interests of the children in many aspects. So I think at this kind of issue we should be able to bring it up and then to discuss in different sectors and then to raise it publicly as a core issue to defend the best interests of the children.
Thank you. Thank you very much.
Well, for me, from speaking from the legal side of view, this CRIA, I must say, is a very, very good model for us to look into. And because at the present that in our legal systems, we didn't do that, and they are causing a lot of injustice in the sense towards the children. Professor Cross has mentioned about any delay is injustice to children. Now, in our present sort of legal systems, is normally whenever the parents have to go to court and they are arguing on custody, cases on custody arguments can take a long, long time. I mean, at least a few months, the worst can be a few years, 5 years, 6 years, sometimes even 10 years or more. And this is quite ridiculous. If we have the CRIA in, then when we formulate the policy, the practice and procedures in the legal system, we can look at how we can deal with this sort of situation. Now we have something like CDR, Children's Dispute Resolution. When parents are disputing their rights in court, the court will initiate a system called they will go into a CDR sort of procedures. Again, the CDR procedures is a long time. And recently, we have another sort of practice going to introduce, and or maybe one court has already been using it, and that is a fact-finding hearing. That is, again, is going to delay any issues on children and determinations of children's issues. So all this, if we have the CRIA systems in, then I will urge the lawmakers, maybe the judges as well, as you mentioned that judges need training. I mean, CRIA is really is one of the methods that when we establish new law or practice and procedures in court systems, that we need to go through that. Now, it's I personally think that any issues dealing with children has to be dealt with and come to a determination within a short period of time, or at least set a timetable, say any issues in custody should be determined within something like 12 months, so that the children are not getting involved in the legal proceeding and become in the middle of the parents' dispute. And something like that, I think I would like to see that in place.
Thank you, Dennis.
Right, so I'm a general pediatrician, right? So I'll usually very practical about what I'm thinking. Right, so all along, in all our decisions on children, right, the best interest of children is usually in our mind, right? Whether against the parents' the wishes or whatever, right? So that's the usual practice. Right, initially I thought I was asked to talk about how can we make children visible, right, under the policies and whatever, right? So how can that CRIA help me in the daily practice, right, to make children visible, right? So that's what I'm thinking.
Yes.
Right, I need to talk about. Right, to me, right, so what's the best interest of children? Right, to me, in the past, we talk about child protection, meaning that a child may be in danger or abused or whatever, right? So basically, we're talking more about child protection, violence from adults, right, rather than on cyberbullying, right? Probably that's another issue, right? So, to me, because of advances in science, right, we understand the impact of adverse early experience on children, right, abuse and whatever, right, that have a lifelong impact on children. And to answer that question, it's intergenerational, meaning that violence, recognize violence in the next generation, right? And also this impact, in a way, is irreversible, right, and lifelong, right? So that's why people mostly talk about prevention, rather than just having a system of meaning early identification, right? To me, that's the most important. How can we do that, right? So to me, the science there is quite clear, right? So the risk factor, whatever, right? Probably this is a local or cultural context, right? But then we have a lot of data on this, right? Coming from all that, right? And how should we tackle that, right? To me, that's one of the questions. How we can identify all those, right? Although we're talking about universal prevention is important, but then targeted prevention is also important, right? So that's, to me, one of the things. And for child abuse, all the studies have shown that screening is useless in that sense, right? It's very difficult to screen for child abuse, right? But then early identification probably is possible, right? But then, to me, because of audience here, and also for all this interdisciplinary interaction, I will call for, we have been talking a lot, probably that's 1970-something. We've been calling for a jointed professional training on child protection, right? And all that, right? Looking all those impact and eventually looking on the children's right issue. To me, children's right meaning that accountability to children, right? All the duty bearers have the accountability, eventually for the best interest of children. Well, how can we look at that, right? And that's the, and we have been talking about mandatory reporting for a long time, and the most objections coming from the professionals, not because they don't like the idea, but of the resource implication, right? So unless we look at the training first, eventually have a capacity and capability, right, from the professional side, and then we can talk about mandatory reporting, and that will require the policy high up, right, and also hopefully the academics, universities will make sure mandatory sort of education be included in the undergrad curriculum. I've been talking a lot about all that, right? But then we look at on the social work or whatever, it's usually an optional one, right? So I don't know. I'm not saying the others are not important. If we think it is important, what should the trainers or future professionals be doing, right? That's the question I'm asking. Right, so after identification, Fernando has mentioned, right, many of them are kept in hospital. To me, they are undergoing another institutional abuse, right? So they have been staying there for months, right? So without a permanent carer, right, and also not 24 hours, right? We have nurses doing rounds, right? So sometimes they may play with the child, right? What one can do with all that, right? So we've been asking for whether should have a crisis center, something like that, rather than hospital. I know. Of course, the other thing is about the sharing of information among the professionals, right? Why can't this information from the social welfare not be transmitted to the hospitals, right? Should we be understanding certain risk factor, whatever? Should we be doing better? All these schools, right? I don't know. I mean, all we're talking about the confidentiality, right? So because time, I'm not talking about. Lastly, is about the CPR, the Central Protection Registry. Well, I think they have been looking into the system for a long time. And all along, the system is basically for identification of child being abused in the past, right? So that I can ring it up, the social worker can ring it up, so that I can, it's a past history, right? But then, to me, the system should be a surveillance system that will help the policy, right? So making every child visible in that sense, right? So will help us identify the risk factors and all that, and also the service lead. And one thing probably is very clear, is that the longitudinal study have shown that all those so-called substantiated child abuse cases, compared with those unsubstantiated, in fact, the outcome are the same. Meaning that those who have been confirmed in the multidisciplinary whatever, while they have been given intervention, when those unsubstantiated so-called, in fact, they are having exposed to a worse environment, and they should be equally be looked upon. Right, so hopefully the system can also integrate so-called unsubstantiated, and also integrate the data from the hospital authority, social welfare, police, and whatever, that eventually we have a full understanding what are the problems we are facing. Of course, the system should also be used for evaluation, how effective our services are, and how the manpower required and all that. And also because our society is evolving rapidly. Right, so I always said in the past, 40 years back, our child abuse cases are very simple. Majority are discipline cases, right, because the child is naughty or whatever. But now it's very complex, right? So I think these are all the things to me is important eventually to make children visible in our system, right, on an individual basis, in the community level. So the last would be child participation. How can we? I'm not talking about how they look at their family. Are they happy? Are they happy in the school? Are they happy in the society? So that will having some reflection on how we are dealing with them, right? On a bigger sense of child protection or safeguarding children in that sense. You know what I mean? It's just not because they are being maltreated in that sense. Because children are very vulnerable in their development. They need nurturing care, they need love, and need tender loving care. If not for all this, their development will not be good, right? So probably I spent too much time on that.
Thank you so much. No, I thought that that's really, really insightful, and I think each of you have provided a very, very distinct but specific perspective that can put the best interest principle into context, and also whether the CRIA would help in achieving some of those aims. I want to start off with Anthony's point about how we need a campaign to encourage uptake. But at the same time, I think what we're hearing is it also needs to be coupled with other efforts. And so I really am grateful to Dr. Chow for sharing that the Joint Professional Training on Children is something that has been floated for a long time. And it really sounds like that kind of cross-professional commitment to ensure that they put sort of children's interests at the center of their professional practice could go a long way towards establishing distinct codes of practice, which also Anthony mentioned, right? If in each profession there is incorporated into existing codes, because I think all professional disciplines already have a code of conduct, but if we could incorporate into that specific aspects pertaining to child protection and also some of the themes I think that Dr. Chow has identified regarding early identification and reporting, data management, evidence gathering, these are best practices that can help eventually translate these into visible but concrete ways of ensuring that children are protected, whichever domain sort of they appear in. I also think that with HKCSS as a meso-level organization, the network that you have can help to encourage uptake among the different stakeholders that you represent. The question I have, however, for each of you is sort of how can we entrench or embed this commitment across the different fields? I mean, Dr. Chow, it sounds like, there's already a very clear position in your profession as to the interest of the child, and then you are battling with resource and other limitations. So I think from that perspective, if there is a legislative framework that provides that that different different actors or different people in positions of responsibility have to be held accountable to provide resources or to implement certain procedures, then that could be one way to tackle some of the gaps that we see currently. But it sounds like there is so many moving parts to helping integrate all of these suggestions. So the lawyers come in sometimes intermittently or a little later, but I think what you said about time frame to ensure that children's needs are met within a reasonable time frame is so important, and it applies across the board. And in fact, with the situation concerning children in hospitals or asylum-seeking children that Fernando mentioned, I think they're in the most critical situation because there's no time frame usually for them to sort of look forward to understand when their situations will be resolved. The question, again, goes back to individual professional responsibilities and whether the councils, the bodies that govern individual professionals, can make more transparent the criteria and the code of conduct so that social workers who have a conflict of value with the schools in which they are placed do not feel afraid then to report schools to the Education Bureau to say, this is my recommendation, maybe get a second opinion from another social worker, and then move forward to look after that particular child, rather than face resistance institutionally. So, I mean, I'm looking to all of you to ask, how can we enhance the sort of receptivity of such a framework? Because it calls for a very high level of responsibility and accountability. And as you said, Anthony, we want to avoid that in some sectors. And it certainly starts with training. How can we encourage universities to introduce or make it mandatory to introduce? Right? So in law, certainly there are some things. So for example, if you want to practice criminal law, you have to do a 3-month pupillage before you're able to do that if you're going to be a barrister. So there must be, I'm sure there are designated core courses and modules. And can this not be one of them to introduce sort of the framework to protect children from a more comprehensive perspective? And can it be done in a cross-disciplinary way?
May I respond to that? Try to respond to that, because I think that's, when I talk about campaign, what I'm saying is like, because I'm a social worker, we have among all the social work knowledge and discourse, we have something called community development approach. The first principle is to getting to know the community. The second step is to making contact and bringing people together. I think these are the most important steps that we have to do. I'm not talking about resources at all. Like, for example, Pooja, you have this framework, right? Now you inspire all these people. And maybe sometimes you can come to the council and then talk with a lot of people and organization. And then that may ignite some kind of interest or commitment of a certain group of people. Then you bring this group of people together and then ask this group of people to lead the campaign and then try to, mainstream the whole thing. I mean, even sometimes, if you even have a code of practice or a professional code, then you have to make this code really implemented. I mean, people will have to bear in mind that there is some kind of code that we have to abide by, right? So I think we have to create this kind of culture so that people are being kept vigilant about this kind of code or framework or really readily in place. So this is what I mean by campaign. And then if you have this visibility of an interest group talking about all this professional code or interests of the children, then other stakeholders would be engaged, right? They would say, oh, maybe we can chip in some resources to, organize some kind of activities, some kind of a movement, something like that. I think this is something that I think is really important. These code and framework are important, but this kind of a momentum will have to be created, and it can be start from a very personal, proactive action. I like the quote from Professor Kors from Mandela. I mean, it's until it is done, right? So if somebody, just one person, then you can activate the whole campaign and then change the whole landscape of the child protection. Yeah, that's what I'm trying to say.
Thank you, Anthony. I'm in complete agreement with you. I mean, yesterday we workshopped the framework with some members of different disciplines, and I already benefited a great deal with the draft and have further thoughts on how to refine it. So I'll be coming to you to share with your network, and I hope you'll take me up on that. Sure.
Dennis? Well, to me, I think it's public education is very important, and introducing this sort of models to the public, telling the public that we should follow something like that. And I think in the end, actually, if I heard it correctly, you mentioned in your speech or your talk that in Norway there is in place in the law that all sorts of policies and decision has to follow this CRIA. And I think something like that we should follow in Hong Kong. And so that every policymakers and lawmakers will consider about all sorts of impact on children. I mean, whether it's long-term, short-term, direct, indirect, all these things has to be considered. And as I said, it's we're talking about when we are dealing with children's sort of interests. One of the best interest principle is to have the matters dealt with quickly. So the time frame we can set it up by way of whenever we we are considering policies or law dealing with children's matters. Now, one example I can quote is that I see in the Hague Convention cases on children adopting from other countries or to Hong Kong. I mean, there is a rule to say that all issues in the Hague Convention cases has to be dealt with or complete within 6 weeks. Now, Hong Kong judges follow that very closely, okay, very closely. So, I mean, if we have something like that, so we can have issues in for the children can be resolved quickly. That is why I'm saying that I hope if we can introduce something like all custody issues should be dealt with within 12 months, something like that. Yeah.
Thank you.
No, if you want to respond to that as well, then I just want to perhaps open the floor for any questions.